Namaskar, hello and welcome viewers. You're watching the special presentation of Sansad TV, Bills and Insight, your one-stop destination for views, news and analysis of proposed legislations of India that have far-reaching implications and impact your life. I'm your host KRITI MISHRA, and today the spotlight is on the Criminal Procedure Identification Bill of 2022. The bill proposes to empower police and prison authorities to take measurements of convicts and other persons for identification and investigation in criminal matters. Before the detailed analysis, let's take a look at the highlights of the bill. The bill allows law enforcement agencies to collect, store and analyze physical and biological samples of convicted individuals. Resistance or refusal under this act shall be deemed to be an offence under Section 186 of Indian Penal Code. The National Crime Records Bureau will be the repository of physical and biological samples, signature and handwriting data that can be preserved for at least 75 years. The Criminal Procedure Identification Bill 2022 seeks to replace the Identification of Prisoners Act of 1920. But why was it needed? Well, the Home Minister assured parliamentarians that the bill has been brought to technologically enhance policing in the country. Next-generation crimes cannot be tackled with old techniques. The bill's objective is to improve the conviction rate in the country, protect the human rights of crores of law-abiding citizens, and send a strong message in the society. And joining us to discuss the bill threadbare is a very illustrious panel of guests. Joining us through virtual platform, Mr. MAHESH JETHMALANI. He's Rajya Sabha member and he's also a senior advocate in the Supreme Court. Mr. BRIJESH SINGH, Additional Director General of Police, Government of Maharashtra. And in the studio, we have with us Mr. SHARDA PRASAD, former Director, NCRB. I welcome all of you on Sansad TV and thank you so much for joining us. Also in the studio, we have with us young professionals and budding lawyers. I welcome all of you on Sansad TV. And before we commence the discussion, here's how our parliamentarians debated this bill.
It is important to ensure that the bill is not in the violation of the basic principles of equality and justice. Sir, according to the Internet Freedom Foundation, bills that involve data collection in any manner have to comply with the right to privacy decision of the Supreme Court.
Certain terms have been left undefined and unclarified. The bill does not provide an exact definition of measurement. The definition provided in clause 2(1)(b) is open to an expansive interpretation. Further, terms used like biological samples and the analysis of biological samples remain undefined.
As of now, there is a low conviction rate in India. This will improve the conviction rate. Murder, the conviction rate in India, murder 41%, rape 39%, attempt to murder 24%.
इस संविधान के कुछ ऐसे अंश हैं जिनको यह सदन नहीं बदल सकता, जिनको उन्होंने बेसिक फीचर्स करार दिया था। और जो आपके मूलभूत अधिकार है, जो संविधान की चैप्टर 3 में पार्ट 3 में उसको दर्ज किया गया है, उसको उच्चतम न्यायालय ने ये बेसिक फीचर करार दिया।
क्राइम भी बदल गए, क्रिमिनल भी बदल गए। क्राइम और क्रिमिनल दोनों आधुनिक तकनीक से लैस होकर क्रिमिनल क्राइम करने लगे और पुलिस को हम आधुनिक तकनीक से लैस न करें, किसी को हाथ पैर बांधकर स्विमिंग पूल में डाल दो कि भैया गोल्ड मेडल लेकर आओ। गोल्ड मेडल क्या, वो तो बेचारा डूब जाएगा क्योंकि आपने हाथ पैर बांध दिए हैं। इस प्रकार की व्यवस्था देश में अब नहीं चलती।
Mr. JETHMALANI, let me begin the program with you. Due to lack of evidence, 7.5 lakh cases are closed every year. The existing law, Identification of Prisoners Act 1920, allowed taking only fingerprint and footprint impressions of a limited category of convicted persons. In that context, take us through the importance of this bill, sir.
Well, I mean, the bill is really meant to encompass technological strides that have taken place, particularly in the field of biometrics, with a view to increase conviction rates, which, as you pointed out, are abysmally low. To give you a counterpoint, in America, in the US, with the use of these new biometric testing, which includes DNA sampling, iris and retina scans, the conviction rate has gone up to 93%. The main intention of the bill is basically to allow modern methods, which technology has afforded us in the detection of crime, to help us in the prevention of crime and in the detection of criminals by identification through biometrics. That's really the main purpose. As you correctly pointed out, KRITI, the old 1920 Act had a very limited scope of biometrics, and that was fingerprints, footprints, and photographs. That's all. And that was the state of technological development at that stage. But now, logic demands that we use these methods for improving our conviction rate.
So I'll just borrow your sentence that the logic demands this, because criminals again are ahead of times, and we also need to ensure that our police are also empowered. But Mr. Singh, talking about empowering the police, let's also look at the other side of the coin. What are the permissible uses of this database, and how do we ensure that there is no possibility of data misuse? That certainly is going to be the biggest concern, sir.
See, one more aspect you have to look at is that this is more exculpatory than inculpatory, in the sense that a chance of wrongful conviction is very low here, because till now our evidence depends on eyewitnesses and witnesses. Here you have strong scientific evidence. You are modernizing police, and you are making scientific evidence become important, and that would lead to convictions, and these convictions would be rightful convictions. It would also shorten investigation cycles so that the police can give better quality investigation, better time to what it needs to do, and also ensure, for example, when you go into a scene of crime, you take fingerprints also of the inmates, because you have to compare, right? So if there's a murder scene or a theft scene, you have to check that whether these fingerprints are from inmates or not. So it's exculpatory in the sense that it takes away the possibility that this belongs to a particular set of people who are innocent. So look at it as a method of proving innocence and then ensuring guilt and reaching to the truth in a scientific manner. And it has enough safeguards as you can go through the reading of the Act. KRITI?
Absolutely, point well taken. But Mr. Prasad, you've headed the NCRB. We are talking about empowering the investigative agencies. We're talking about improving the conviction rates, upholding the human rights of crores of law-abiding citizens, sir. But how do you think we need to ensure that there is effective implementation of this proposed legislation?
You see, the proposed Act has got lots of points through which it will be controlled. For example, the rule-making power, which was in the earlier Act with the state government only, now the rule-making power has been extended to the central government as well. This is the first. And then areas in which the rules will be made, that also has been specified. So I believe that there will be ample provision for making the rules properly and controlling the things. And what are the areas that also be specified? For example, collection, then after that analysis, storing, and even the deletion of records, all have been already specified. So there will not be any difficulty in implementing the law. And National Crime Record Bureau has already been the storehouse of fingerprints. And we have been doing this task for last more than 100 years. So I presume that there will not be any difficulty when certain new areas like iris recognition or you can say retina recognition, those techniques are added. These are the new things which have been added, and something more will come because the area have been widened. The area of data collection, or let me say measurements, that have been widened to include whatever the most technological advances are there in this field. So NCRB is the right agency which shall be able to look after the matter. And it's a matter of pride that though we have been holding the data of fingerprint for more than 100 years, there has not been a single case where there is a leakage of data and it's a wrongful use.
Mr. JETHMALANI, you may recall that when this bill was discussed in Parliament, opposition raised concerns over privacy. They also said that the legislation goes against the Supreme Court's landmark judgment in the Keshwanand Bharti versus Union of India case. How do you allay those concerns, sir?
Well, first of all, I mean, this argument is totally misconceived. I actually thought that this bill will be unanimously passed because there is no downside to this bill. Now, this right of privacy, as far as it's concerned, the Supreme Court judgment, which members of the opposition relied upon, itself says that the right of privacy is subject to detection of crime. So, detection of crime is a higher principle than even the right of privacy. Because, I mean, you are basically, as Brijesh pointed out, not only improving the conviction rate and therefore helping to punish the guilty, convict and punish the guilty, but equally you are also helping the innocent. And that is because witnesses may lie, as he again pointed out, biometrics don't lie. Now, you had allowed all this time, nobody raised any voice against fingerprints and footprints. All you've got now is advanced biometrics. You have new forms. I mean, the retinal and iris scans now are almost foolproof. So it helps you. I mean, I gave an example in Parliament that Carnegie Mellon in the United States has a project which is now being implemented where you have something called a long distance iris scanner, right? So now when a murderer or a thief runs away from the scene of the offense in a car and a police car chases him, if the murderer so much as glances in his rear view mirror, you get immediate identification. The driver of the police car at the back, from his iris feedback, he'll match it with his record in his police car, and he'll be immediately, before he gets out of the car, he's identified who the criminal is. Now, why would anybody, I mean, you have to be an enemy of science and a protector of criminals to say that we don't want this kind of technological advantage. And as I pointed out, in any case, fingerprints were there in the past. They were part of your biometrics. Who ever complained about a database containing the limited biometrics which were there in the 1920 Act? You've only got now better identification techniques, that's all. And the right of privacy can't be carried so far that you allow criminals to get away and sometimes innocent people to be wrongly punished.
All right, Mr. JETHMALANI, Mr. Singh is vehemently agreeing with you. Mr. Singh, the impact of this legislation in minimizing the threat from organized crime, cyber criminals and terrorists who are proficient in identity theft and identity fraud as well, sir.
Right. I would like to take you a bit back. In fact, the science of fingerprints almost started from India. The first fingerprint bureaus were from India. So look, we were at the forefront of scientific developments in policing then. And in fact, this is very late that we are adopting scientific evidence and giving it a legal standing. And this is going to help us in many ways. The way the Aadhaar stack has helped everywhere, right, from service delivery to businesses. Similarly, identification of Prisoners Act now with this bill is going to help you identify prisoners across states. Prisoners in the sense, people who have committed crime across states. So if you have a central database, then it's possible to match a person who has, let's say, committed a crime in Maharashtra and run away to West Bengal. So there he won't be able to run away. Till now, you had this, kind of jurisdictional limitation where systems were not ready. Some people were using manual system for fingerprint. Now, if you have a single concerted national database, then anybody, committing any crime anywhere would be immediately, to say it in Hindi, the Janampatri would come out instantly because, this is linked to the demographic and crime records data. As NCRB has done some wonderful job in maintaining crime data and also now with CCTNS, you can search across the country. So a criminal is not free now. Today, the possibility of detection and the possibility of arresting criminal across the country is very, very high, and it's a great development. KRITI?
All right, so we're talking about tech advancements, sir.
Yeah.
We know that FBI has database of over 4 crore fingerprints. Mr. JETHMALANI has been talking about global best practices. What are the other practices that India can adopt going ahead, sir?
You see, first thing is standardization. Whatever standardization is prevalent the world over, same standardization will be adopted in these matters also. In fact, certain standardizations are in the matter of development, like iris recognition and retina recognition. There, the scan has to be technologically world standard, and that is being adopted in a phased manner. Other things are being adopted, so we will not be lacking in the standardization or even the techniques. We are adopting the latest techniques, and I hope they will be the best one in the world.
All right, so as they say, We're late. Nonetheless, we've not missed the bus.
Yes.
Now let's take some questions from our audience here. Please go ahead, introduce yourself and speak your mind.
As the bill states, the criminal identification bill, that as you also stated and pointed out, that the samples will be stored for more than 75 years. So what is the provision for that? Because it is a huge task in itself to store all the samples together.
Mr. Prasad, would you like to take that one?
You see, the storage is not exactly in the physical form. Storage is in the terms of data. That means the entire thing will be converted to a data, and data will be stored in the magnetic media or whatever media is available, electronic. The Act talks about digital and electronic media. So storage in media is not a problem at all. And it's not that we are storing the physical samples. So there won't be a difficulty at all. And security is also not an issue, because the latest security standards will be applied. Plus, as usual with the National Crime Record Bureau, the data of National Crime Record Bureau is not only stored at its headquarters, it is replicated in 2 other locations in the country, so that in case there is a problem at one location, suppose some earthquake or some other thing, then that same data is available concurrently at 2 other locations in the country. So there won't be a difficulty in storage, retrieval, analysis, or the later on at some point deletion. All will be taken care of. Yeah.
All would be taken care of. Let's take another question now.
As in the discussion, we went through a statement that if the person whose data is to be collected, he does not give his data, then the bill provides that force will be used. Is this not against the constitutional mandate provided under Article 20, Clause 3, that no person can be a witness against himself, and further moving, that you are using force which is against the judgment of the Supreme Court, that using a force against person, taking his who is not giving his data, is this not against the constitutional spirit? Thank you,
Let's
sir.
take that question to the legal domain. Mr. JETHMALANI, would you like to take that one?
Look, as I pointed out, it's a very good question, by the way, but the detection of crime takes precedence over, it's an exception to the right of testimonial compulsion. Now, as far as fingerprints were concerned, you could always compel somebody to give his fingerprints in the past. So also, not only the police, but even the courts during the case of the trial, as per the Criminal Procedure Code and the Evidence Act, they had a right to take, where they had a doubt about a document, its handwriting or its signature, they have a right, both during trial and even during investigation, the police have the same right, to ask people to give the signature and the handwritings. So that everything, your biometrics are your personal property. But when you become a suspect in a crime, your biometrics, to help you, and everybody should welcome it. It will help you if you're an innocent person to evade the clutches of the law. And if you are a criminal, and only hardened criminals should really object to the biometrics. If you are a hardened criminal, you will say, no, my biometrics should not be the matter of a database by the National Crime Record Bureau, because then I'll be easily detected. So it helps, again, I repeat, to protect innocent people. It's not a compulsion. It's for the enhancement of justice. This bill, this act now, is for the enhancement of criminal justice.
And all right,
if I may add to this, sir. that
please,
if you
Mr. Singh, go ahead. The floor is yours.
Yeah, if you compare the law of arrest, the law of arrest also states that you may use force necessary if the person is resisting arrest. So there are, provisions built in law where the person is not complying with law. So if somebody is not acting in the spirit of law, then the majesty of the law will ensure that he complies. And that is a similar provision I see here also. KRITI?
All right, as our panelists are saying, that prevention of crime is more important, and of course, upholding the rights of crores of law-abiding citizens as well. Let's take another question now.
The only concern that I had while reading this bill was that now in the present bill, identification bill, we have extended the right to give permission for the collection to even to the executive magistrates. That means it could be HDM, it could be district magistrates. So my concern is, will this not lead to bureaucratic tyranny in this country? And in the previous law, the person, the officer, police personnel who could collect was of sub-inspector level. But now in our current bill, we have extended it to even sub-constable. So I am thinking that as per the current police training and bureaucratic situation of this country, will it not lead to any trouble and tyranny? Thank you.
Mr. Singh, are we unleashing bureaucratic tyranny in the country?
No. So if you look at the provisions carefully, it talks about proceedings to keep good behavior. So those are called Chapter 8 proceedings. They are very specific. 107, 108, 109, 110. These are very specific, provisions about keeping peace and maintaining good behavior. And only in that specific case, the executive magistrates have been provided with the power to order collection of these samples. In fact, if you look back at the Identification of Prisoners Act 1920, it also had similar provisions where there was a schedule of where we could collect fingerprints, palm prints of people in cases of chapter proceedings also, and that can be authorized by, in this case, executive magistrates. KRITI?
All right, let's take the last question now.
As you have said, sir, that technology will be so advanced that it will capture retina even from the car side mirror. So will it not be against the fundamental right, that is right to privacy, as it will be done without person's consent? As you have said, sir, it will not known to that person who is accused, and the person will be convict only. So it will not be against the privacy.
All right, Mr. JETHMALANI. Utsav says, where are my rights as an individual?
Why? See, merely because somebody might misuse something sometime. But why would anybody do it? Why would anybody want to misuse your biometrics? Basically, the National Crime Records Bureau has got enough firewalls to protect leakage. The second thing is, what is this? Why are your biometrics so important? I mean, as I pointed out, it helps you establish crime. It's all for a good purpose. Whether it's your fingerprints or your now your iris and retinal scans, what is this misuse aspect? It's only in a database, which is digital-based database, kept by the National Crime Records Bureau. The gentleman, Mr. SHARDA PRASAD from the National Crime Records Bureau, has told you that we've never had a case of leakage. But to enhance biometric method, now the example I gave you said this long-distance iris scanner. It just means that when a criminal is running away, you can catch him faster. Instead of waiting to find out who it is. You know what this normally does? As the Home Minister pointed out in Parliament, this act is meant to replace third-degree methods. It eliminates third-degree methods. Normally what happens is police often resort to it, or used to resort to it. They thrash people up in jail and get their confessions, and then they make a recovery evidence, and then the witnesses come to the scene, and so on and so forth. Now this will eliminate all that. It's a scientific method. It's an advance in civilization techniques of investigation. And that should be welcome. Everybody in this country should welcome it. We should all be pro-science and not anti-science.
So let's be pro-science and not anti-science. That's what Mr. JETHMALANI is trying to tell us. So the bill provides legal sanction for taking appropriate body measurements of persons who are required to give such measurements, and will make the investigation of crime more efficient and expeditious, and will also help in increasing the conviction rate in the country. On that note, thank you so much for joining us, Mr. JETHMALANI, Mr. Prasad and Mr. Singh. Next week, we'll return with incisive analysis of another important bill. Till then, take care and stay tuned to Sansad TV. Namaskar.